In appeal of Simkova against the Secretary of State for Working Pensions.
My lords, my lady, I appear for the appellant in this case, Ms Simkova, with Mr Castle. My learned friend, Ms Smythe and Mr Mackay appear for the Secretary of State. Sir James, I understand, is indisposed by coronavirus.
I'm sorry to hear.
Not norovirus, rather.
I hope you'll soon be recovered.
And the intervener, the Air Centre, is represented by Mr Bewley and Mr Fraser. We've agreed a timetable with me speaking till about 3:30, half an hour for Mr Bewley, and Miss Smythe will have tomorrow less half an hour for a reply. Once allowance is made, in this case, for the areas of agreement and non-dispute, the 7 issues in the Statement of Facts and Issues really resolve in our submission to 3 relatively simple questions, albeit bundled in 2 regimes of Byzantine complexity. The first source of Byzantine complexity is the EU scheme for social security coordination, currently contained in Regulation 883, which itself builds on the old Regulation 1408/71. These bits of EU secondary legislation, I think, have generated more case law than any other area of EU secondary legislation by some comfortable margin. But in connection with that EU social security regime, there is, in our submission, one key feature. The child element of universal credit is a clearly distinct part or segment of the universal credit regime. And what is more, it is, on any view, the clear successor to the benefit that was child tax credit, with which it shares many key attributes. For a case about family benefits, it's an irony that these 2 forms of payment are so very closely related. If they're not identical twins, they are certainly very proximate family members. And changes in procedure aside, CTC and child element are functionally identical, save for one key difference. It is now a precondition to the receipt of the child element that the claimant can first show that they can receive a universal credit standard allowance. And that leads to the first question, which basically captures everything in issues 1 to 4 in our submission. And it is, I suggest, this. When does the consolidation of a coordinated, means-tested family benefit, here CTC, with other formally distinct benefits into a single payment and claims regime with a single set of means and income testing and tapering provisions, when does that change the benefit, if at all, so that the consolidated benefit is one to which the distinct regime of the regulation no longer applies? The issues of principle is thus to take how the Court of Appeal formulated the Secretary of State's submission below, see paragraph 28 of their judgment, electronic page 217, it is whether or not the regulation applies to a generalised blended benefit system, which in turn rather begs the question, what is a generalised blended benefit system? We say, ultimately, that addressing that key principle requires the court to identify the correct perspective or focus. What does one concentrate upon? And here, the rival submissions are these. Is the correct focus, as the defendant suggests and as the Court of Appeal agreed, upon the fact that there is a child element available only as an add-on element to universal credit, and that universal credit as a matter of national law is a single benefit, and that the standard allowance of universal credit is social assistance? Or is the correct approach one which concentrates upon the fact that even within universal credit, there remain a series of distinct or self-contained elements and payments, and where those self-contained elements or payments address an Article 3 risk, that element is a social security benefit. That's the terrain for the first major theme of inquiry. The second source of complexity is, of course, the legislative arrangements for exiting the EU, along with the requirements of the Withdrawal Agreement, to which such arrangements give effect. And in connection with that second source of complexity, this case again has one striking feature. As we explain in detail in our written case at paragraphs 139 to 142, it is a case pertaining to an entitlement which, if we're correct on our construction of the correct application of the regulation, it's an entitlement which is a continuous one, and a continuous entitlement which has spanned the period before exit from the EU, the transitional period of 11 months, and about 18 months after IP completion day. So when the decision at issue was taken, the UK was a full member of the EU. When the FTT opined, we were in the transitional period, and by the time the proceedings came to be before the Upper Tribunal and the Court of Appeal, the case was being conducted against the backdrop of us having left the EU. But throughout that period, Ms Simkova's entitlement under Regulation 883, if it existed, is unchanged. It was a continuous entitlement. So this case is not like Lipton, where there was a one-off event, a delayed boarding, generating on that day a one-off entitlement to payment. There was instead a continuing entitlement. And that is evident from what will happen if we prevail in this case, because at its heart, this case concerns a decision revising entitlement. If that decision is set aside, what will happen is that the entitlement that was established in 2017 will continue until such point in time as the Secretary of State can lawfully take a supersession decision. That is a decision saying you are no longer entitled to the payment. And the first date upon which such supersession decision will be possible is effectively the 1st of July 2022, which is the date when Markus Simkova finished his education in Slovakia. And it's that continued entitlement and the fact that this litigation will determine, as a matter of debt, as a matter of private law entitlement if necessary, Ms Simkova's entitlement to receive the child element from the period from the 1st of January 2021 to the end of June 2022, that gives it its very special character and is sufficient in our submission to generate the application of the Withdrawal Agreement and with it the potential for the case to be referred under Article 158 of the Withdrawal Agreement. So that continuing fact pattern leads, we suggest, to this central question. Does Article 158, properly construed, confer a power or jurisdiction to refer a question of interpretation to the CJEU relating to Regulation 883 when the dispute arises before the UK's departure from the EU, but relates to a potential continued entitlement that operates in consequence of the Withdrawal Agreement without change until well after IP completion day. Now, the position between the parties can be pretty simply stated on this issue of principle. The defendant points to the narrow language to adopt a narrow view, to say this case relates solely to the law pertaining on the 17th of October 2019, ironically the day that the Withdrawal Agreement was concluded, yes. Same date as the day of the date of the decision, and therefore they say the Withdrawal Agreement is not in play. And we say, no, this dispute will resolve, as a matter of law, our entitlement after the 1st of January, and that is sufficient to make this into a question of interpretation caught by Article 158. That then leads to the third question, which is, should this court exercise its discretionary power to refer the case to the CJEU under Article 158, whether as to the substantive dispute, or as to the substantive dispute and any question you may have about the scope of the power to refer in Article 158 itself. So those are the lines of battle how do I propose to proceed? I'm going to spend about the next 2 hours, 2.25 hours on the first topic, the proper construction of the regulation. And I'm going to take all issues about the withdrawal agreement in a second phase, taking about an hour. During the first phase, Mr. Castle is going to address you briefly on two topics, the general link between CTC and the child element, and in particular, the operative test of residence under both benefits, which we say is substantively the same. So, can I start with the regulation? This is the bit where it's a bit like the Rocky Horror Picture Show. Let's do the time warp. We're back to EU law as we used to argue about it up hill and down dale. And the coordination regulation, for anyone who spent time with it, is one of those things that twists your head every time you come back to it. At least it does mine. We address it at pages 2 to 7 of our written case. And as we state in paragraph 7, Regulation 883 replaces, but effectively largely consolidates, the structure and approach of the old Regulation 1408/71, which means that all of the case law from that old regulation, in particular the seminal case of Newton and Hughes, about which you'll hear a fair bit, all of that is pretty much directly transposable to the equivalent provisions under Regulation 883. The regulation is at page 674 of the electronic bundle. It's a regulation whose aim is the coordination rather than harmonisation of member states' social security systems. But that distinction, important as it is, does not mean that the regulation does not contain some hard-edged rules which, where operative, require material change to a domestic scheme of benefit. And that's because, whilst using the tools of coordination, the regulation still has the overarching objective of promoting free movement by such coordination. And we would suggest that's apparent simply from reading the recitals either to Regulation 883 or the regulations to the old Regulation 1408/71, which you'll find at electronic bundle, page 658. I'm not going to take you through the recitals. Now, the defendants are quite right to say that the regulation doesn't constitute some sort of guarantee in all circumstances that if you exercise your rights of free movement, there won't be any disadvantageous consequences in so doing. But what the regulation seeks to do is to set a floor, a lowest level, if you like, on the sorts of disadvantageous consequences that might otherwise accrue. The result, therefore, is broadly one in which member states make decisions as to whether or not to create benefits, how to set conditions of entitlement, how to fund the benefit, who to pay, how much to pay, for how long. All of those decisions are taken with a largely free hand. It means a member state may have a plethora of generous benefits or a few parsimonious ones. Those are all matters of domestic social policy. But what the regulation does is set basic rules that coordinate how such domestic schemes can operate for EU nationals whose exercise of their free movement rights has led to a material cross-border situation. And those coordinating rules therefore curtail some options in benefit design in some circumstances, and that's most obviously in relation to residence-based conditions of entitlement, and that's what we're arguing about in this case. Those curtailments are necessary because the regulation's basic goal is to require member states to adjust their benefit systems to cater for those cross-border fact patterns. The most typical situation is, of course, when one person has moved from state A to state B to pursue work or self-employment there, but they may have had a history of work somewhere else. How do you aggregate periods of contribution, say, or deal with requirements about continuation of residence in circumstances where someone may have aggregated employment abroad? Equally, you may continue to reside in State A, but work across the border in State B as a frontier worker, a fact pattern relatively common in Ireland and Northern Ireland. and that used to be somewhat less common as between England and France. And again, you can see how that scenario would trigger problems if residence-based rules are required because the frontier worker is residing in France or the Republic of Ireland, as the case may be. And then lastly, the last typical situation is where a worker comes to work in a host state but leaves their family behind and supports their family with their earnings from the host state. So the worker is in state A, but their family is residing in state B. That's a perfectly common cross-border situation which these regulations are designed to address, and it's an exemplar of Ms Simkova's situation because she came here to work back in 2005. She obtained permanent residence well before Brexit under Article 16 of the CRD, and she supported her son, who lived in Slovakia, with his grandparents. All of those situations, therefore, trigger the operation of the regulations coordinating rules if what is at issue is a benefit to which the coordination applies. The aim of coordination, once it's operative, is to ensure that a worker is not worse off, in broad terms, in consequence of that decision to work abroad. And the particular traps to be avoided by this mechanism of coordination is a situation, first, where you can't identify which law applies. Secondly, where you have a law that applies, but you find yourself effectively caught with a law applicable to you that then denies you all entitlement based on a residence condition or something of that kind. Or, thirdly, rules that don't fully or properly take into account your overall pattern of work or contribution. The coordination affected by the regulation is obviously not of all forms of social security benefit. It concentrates only upon certain risks that are closely related to work or self-employment. Those coordinated areas are set out in Article 3 of the regulation, electronic page 686. Page number is wrong, forgive me. 686. And you can see, in particular, listed there, after sickness, maternity, old age benefits, J, family benefits. And whilst we're looking at Article 3, can you please also look at Article 5, the residual category of social assistance. The regulation shall not apply to social and medical assistance, or B does not apply. The definition of social assistance employed by this regulation is residual, and this is a trap for the unwary, it's a bespoke definition applicable only to this regulation. And most confusingly, therefore, where you see the words social assistance in other EU secondary legislation, most noticeably the Citizens' Rights Directive, it does not mean the same thing.
So there's a wider and a narrower
Indeed.
Social assistance. And is this the wider one or the narrowest?
This is the narrowest one.
This is the narrowest, right.
The narrowest one. The case of Bray establishes that social assistance, the term used in the Citizens' Rights Directive, actually encompasses special non-contributory benefits in the language of this instrument. And the case of Commission and Parliament, a Commission in the UK establishes that it also encompasses full-blown coordinated benefits if those benefits are non-contributory and effectively means-tested. And because those forms of benefit, child benefit and CTC was what was at issue, were non-contributory, the state was entitled to submit them to a habitual residence test. So it's a very confusing terminology that means a very narrow thing in the context of Regulation 883 and means pretty much most things that are coordinated by Regulation 883 bar the old-school conventional contributory benefits when you're dealing with the Citizens' Rights Directive. What constitutes a family benefit is defined by Article 1Z, which is back at page 686. It means all benefits in kind or in cash intended to meet family expenses, including advances of maintenance payments and special childbirth and adoption allowances mentioned in Annex 1. And we set out the case law at section 12 of our written case about how that term has been understood. We don't perceive there to be any dispute about that as the test for family benefits. It's more how that test is applied to something that is aggregated with other elements. So back to the regulation. Having identified the broad area of risk or benefit coordinated, the first task in any potential application of this regulation is to work out which state is competent for the payment of benefits for any particular person, using in effect what is the conflict of laws rule in Title 2. Typically, because the special cases dealt with by Articles 12 to 15 are pretty obscure, typically you only have to look at Article 11. And Article 11 operates, in effect, by a hierarchy of rules. The place where you work or exercise self-employment, that's the place, the single place to which the legislation applies to you. Same for civil servants and their employment or office. And then there is an end rule in 11.3e that says where no other rule applies, then it shall be the place of residence that generates the single applicable legislation. Now, this is no doubt a key part of the regulation's operation, but to describe this as the main function, as the Secretary of State does at paragraph 5 of her written case, is not correct in our submission.
And how do you decide where the person is pursuing their activity? Is that where the company they work for is based, or where their salary is paid, or...?
Well, it's typically, if you're employed, it's your place of employment. If you're self-employed, it's the place you're reporting to work. But there are potential issues about cross-border work in those circumstances. But with respect, they're not material here, because it's absolutely apparent here that Ms Simkova was working here as a regular employee. And insofar as there were periods when she wasn't working here, it's apparent she was residing here. So there is no dispute, but that the legislation applicable to Ms Simkova under this single state test is the United Kingdom. Now, of course, identifying that single state is the first starting point, but what the regulation then goes on to ensure is that once the legislation has been identified, that legislation works in a tolerably acceptable fashion. So the conflict of rules analysis is only the beginning of the analysis. It's not an end in itself. What you then have to do is to apply the particular coordinating rules that the regulation contains. And those coordinating rules fall into two camps. There are the general coordinating rules that are contained in Title 1. I'll take you to those in a minute. And then for each benefit type, sickness benefits, invalidity benefits, family benefits, there's a series of distinct specialist coordinating rules that apply to take account of the special characteristics of that type of benefit. And they're set out in Title 3, chapters 1 through to, I think it's chapter 10. So the first thing one needs to look at is the coordinating rules in Part 1. And probably the most frequently invoked rule is the general principle of non-discrimination on grounds of nationality, which is at Article 4, page 687. Quality of treatment is one of the coordinating rules. The next most important, and it's particularly important for special non-contributory benefits, as we'll see, is the general rule in Article 7, waiving of residence clauses. Unless otherwise provided for by this regulation, and that's a reference to either the specific provisions in Title 3 or the specific provisions relating to SNCBs, cash benefits payable under the legislation of one or more member states or under this regulation shall not be subject to any reduction, amendment, suspension, withdrawal or confiscation on account of the fact that the beneficiary, that's Ms Simkova, or the members of his or her family reside in a member state other than that in which the institution responsible for providing benefits is situated. Now, that reference to members of his or her family is then, in turn, a reference across to the definition supplied in Article 1, Roman 1, at page 683. And it's the third limb of this definition that's important. So 1 Roman 1, number 3. If under the legislation which is applicable, under subparagraphs 1 and 2, a person is considered a member of a family or member of a household only if he or she lives in the same household as the insured person or pensioner, this condition shall be considered satisfied if the person in question is mainly dependent on the insured person or pensioner. Now, that is the source of the alternative approach that we say is required by the regulation once it is a coordinated benefit in relation to a family member. It becomes a test of whether or not Markus is mainly dependent on his mother, even though he lives in Slovakia.
But you accept that this only applies if the child element is a family benefit?
Of course, my lady, yes. So back,
is this rather than Article 67?
It's actually both, because Article 67 is a kind of sectoral implementation of the general rule in Article 7 and this definition, and it's to exactly the same effect. The last of the relevant coordinating rules, and it's one that cuts the other ways, electronic bundle, page 688, is a rule preventing overlapping of benefits. In each state, unless otherwise specified, this regulation shall neither confer nor maintain the right to several benefits of the same kind for one and the same period of compulsory insurance.
Sorry,
Now,
you're reading now from
Article 10.
10, thank you.
Page 688. Now, family benefits do in fact generate those types of problems. Why? Because very often you'll have two members of a family working. One may be working in one state, one may be working in another, and that work generates an entitlement to family benefits under both sets of legislation in relation to the same children. And that's why, when you get to the family benefits rules, there are particular overlapping benefits rules in Article 68. So those are the general rules. If you then go on to Title 3, you can see the provision benefit by benefit type of the specific rules set out here. And these specific rules govern whether or not the applicable legislation is in fact the applicable legislation. So they make exceptions to the Article 11 rule. They govern particular rules on aggregation, particular rules on payment, so they may provide for payment of a benefit by an institution in the state of residence on behalf of the competent institution, and particular rules on overlapping benefits. And they are each much litigated. For instance, the sickness provisions in Chapter 1 of Title 3 generated the reference in Tolley, which was all about whether or not the benefit was a sickness or an invalidity benefit, and whether or not the conflicts rule was displaced by the provisions of Article 22. The provisions we're concerned with are in the family benefit title, that's Chapter 8, page 717. You've got Article 67, which my lady referred to. This is the chapter equivalent of Article 7. And you've got Article 68, which is the overlapping benefit rule, which was the provision effectively at issue in the case of LACHEB, which we'll come to, that dealt with what happens when you have overlapping entitlements by dint of multiple family members working. And we spelt out the operation of Article 68. It's quite fiddly. In paragraph 19 of our written case, electronic page 97, nothing presently turns on its details. Suffice it to say, what happens is you get one benefit, and then you get a top-up if there's a difference between the generosity of the benefits, a supplement paid by the second state. So pulling out all of this together, how the scheme works is this. First of all, you work out the applicable law using Article 11. And here, as I said earlier, there's no doubt that UK law is applicable. Secondly, you ask whether or not the benefit being sought is one of the coordinated benefits under Article 3, and that's the crunch area of dispute. The only candidate benefit in play in relation to child element is family benefits, and that requires the application of the standard test to see whether or not something is a social security benefit, and that standard test is, first of all, to see whether or not it's paid as a matter of entitlement or as a matter of discretion, and secondly, whether or not its purpose is to respond to one of the risks listed in Article 3. And then thirdly, if you do have a coordinated benefit, you apply the coordination rules to work out whether periods of contribution or periods of residence requirements are met, and to work out whether or not residence conditions on entitlement, as applied either to the insured person or in the case of family benefits as applied to their family members, are to be disapplied. And that disapplication, where it occurs, only occurs to the extent that the regulation is in play. So if the child element is a family benefit and it requires the residence rule to be set aside, it is set aside for that purpose, but it does not follow that the test of regulations, the test of residence as set out in Regulation 4 of the relevant universal credit regulations is to be disapplied for all other purposes for which it's employed, for instance, in relation to the calculation of housing elements or other matters of that kind. And that's what brings us back to the question of focus at the end of the day, because if the focus is upon the particular element in question, then many of the potential problems, the sort of chicken licking, the sky will fall problems painted by the Secretary of State actually fall away, because if the correct focus is on the child element, then the analysis we urge only applies in relation to the child element, and the rest of the workings of universal credit are left untouched. If the analysis is universal credit or bust, all of its allowances, all of its elements being taken in one overarching inquiry, then the practical problems identified by the Secretary of State's analysis do arise. And the very fact that they do arise is the strongest conceivable pointer against that being the correct analysis. The last thing I should mention in this general tour of the legislation is the special non-contributory benefits category. It's very important to understand SNCBs for this case for three reasons, even though this case isn't about an SNCB. The first is that it's critical to understand that SNCBs were effectively a legislative response to the decision in Newton and Hughes to the effect that if a benefit had a hybrid character, it was in part about subsistence income or alleviation of poverty, but also in part about addressing an Article 3 risk. It was to be treated as a coordinated benefit under the regulation. CJEU decided that. The legislature responded by creating the SNCB category, the purpose of which was basically substantial reversal of Newton by making benefits in that category non-exportable. And that's extremely important to understand whether or not there is a necessity for the approach that the Secretary of State is urging, because on our submission, the correct thing to do, if child element is in fact coordinated as a hybrid benefit, is to secure its listing as an SNCB, and that will stop it being exportable. Secondly, it's important to understand what the criterion of special is in the definition of special non-contributory benefits. And that definition is one that turns upon the addressing of the Article 3 risk being supplementary or ancillary to the addressing of the problems of subsistence income. In other words, it's directed in its language, and I'll show you the provision in a second, at precisely the type of circumstance about which we're arguing. And that means that if the Secretary of State's analysis is correct, in effect they avoid the potential need for categorisation as an SNCB. And then the last reason why you need to understand the SNCB category is it's unfortunately central to understanding the decisions in Commission and Parliament and Bartlett and the reasoning therein. So that's why they're relevant. They are a halfway house between coordinated social security and uncoordinated social assistance. That halfway house was created after Newton. I'll take you to the Newton case law in due course. But let's just start with the actual definition itself, which is at electronic page 719. And it's a threefold test. You have to show that the benefit is special in one of the two senses used in Articles 2A, Roman 1 or Roman 2. You have to show that the benefit is non-contributory, and you have to show that the benefit has been, not is capable of being, has been listed in the relevant annex, which is now Annex 10. At the time of Commission and Parliament, it was Annex 2A. And it's the first part of the special definition that's important. The second relates to disability, and that is a reflection of Newton, which was a disability case. The first limb relates to supplements to minimum assistance benefits, which was the fact pattern of Hughes, which was decided a few months after Newton. A benefit is special if it's supplementary, substitute for, or ancillary cover against the risks covered by branches of social security referred to in Article 3, and which guarantee the person concerned a minimum subsistence income, having regard to the economic and social situation in the member state concerned. And it's those words, supplementary or ancillary, that are particularly important, because what they're effectively recognising is that even benefits which are supplementary or ancillary are coordinated unless they are also non-contributory benefits and have been listed in the relevant annex. In other words, even something that meets the definitions in Limb 1 and Limb 2, so it's special and it's non-contributory, will be a coordinated benefit unless it is listed in Annex 10. And no aspect of universal credit has been listed in Annex 10, and that means you are left effectively with a choice between coordination and the usual rules of coordination or no coordination at all. The consequences of being a special non-contributory benefit are spelt out in Articles 70.3 and 70.4. The first consequence is that Article 7, that waiver of residence rules I showed you, that will not apply to the benefits referred to in paragraph 2. And the second consequence...
Which won't apply?
Article 7, the waiver of residence rules, and the other chapters of this title shall not apply to the benefits referred to in paragraph 2. So that provision disapplies the general coordination rules, coordination rule in Article 7, and all of the special rules, for instance, Chapter 8. And what you're left with for an SNCB is effectively a residual non-discrimination on grounds of nationality rule, Article 4, which does continue.
And that's what you mean when you say it's not exportable?
Indeed.
Yes.
Indeed, Renee. That's the jargon that the cases people probably...
Yes, when you talk about exportable, you think of people going from here to there, but it's actually also people coming from there.
Indeed.
Yeah.
Indeed. And then 4 provides the benefits referred to in paragraph 2 shall be provided exclusively in the member state in which the person concerned resides in accordance with its legislation. Such benefits shall be provided by and at the expense of the institution of the place of residence. So at that juncture, I'm going to hand over to my learned friend, Mr. Castle, who's going to talk you through the links with CTC and child element before I come to the main submissions.
Yes, Mr. Caswell.
Thank you, my lords, my lady. My learned friend, Mr. Delamere, promised you 2 topics from me. I've got more like 2.5. The first half is the relationship between child tax credit and child element. I'll deal with that briefly before going on to the main point, the points of commonality between the two. And then the final thing I will do, point I will take, to show the effect of coordination on child tax credit, and luckily for everyone there's a worked example in the bundle. So, beginning then with the relationship between child tax credit and child element, universal credit as a whole was formed to replace 6 former benefits. We set those out at 23 of our written case, 99 of the bundle. Parts of those have been folded into the universal credit standard allowance. And taken on its own, if it's the only thing in play, standard allowance is social assistance. We see that because if we take you through the entitlement conditions at 380 of the bundle, so this is section 9 of the Welfare Reform Act. And what section 9 shows, all it shows is that there's no special additional conditions to getting standard allowance over and above the basic conditions for universal credit. Those basic conditions are at section 4 and section 5. Section 4 is at 375 of the bundle. One.
Sorry, just give me that page again.
That is 375, Section 4, Welfare Reform Act. Basic conditions are set out at 4.1. In brief, they are age, not too young, not too old, is in Great Britain, not receiving education, and has accepted a claimant commitment. There are then financial conditions, which are at Section 5, Bundle 377. And there's a capital limit and an income limit. They're at 5.1a and b. None of these criteria meet Article 3.1 risks. But if we now look at the additional supplementary element for children and how that's described, I'm going to first go to the white paper. This is a bolt-on payable only if you have responsibility for a child.
But you have to meet the Section 4 and Section 5 criteria as well.
There is a, yes, there's a sort of gateway entitlement.
Sorry, I didn't hear what you just said.
Child element is a bolt-on payable only if you have responsibility for a child. I'll show you that test in a moment, but first, if I could just take you to the white paper, 2010, and just parachute you into Chapter 2, page 38. That's at 2856. Paragraph 38. Describes the policy goal of child element. Government is committed to providing the financial support less well-off families need to cover children's living costs. We will therefore include fixed amounts within universal credit to provide for these costs. The amount will be based on those currently provided through child tax credit. They'll be additional to child benefit, as child tax credit was. So the idea was to maintain the purpose and conditions for the grant of child tax credit as an additional or ancillary or supplemental allowance to cover children's living costs.
And child benefit there, is that payable to everybody regardless of their income? Or is
It is payable, I think there's a cut-off of £50,000, but yes.
Right.
If you claim it, yeah. Yes, yeah. If Mr. Debman reminds me, if you earn above £50,000, it comes back to you in your tax return. But yes, it's short, it is payable to everyone, yes. Commission and UK, the child tax credit case was also about child benefit. So the goal was to retain a family benefit element of universal credit. And in brief, the results in the legislation you can see clearly at 567. This is Regulation 36, Universal Credit Regulations.
Sorry, what was the page again?
567.
And the goal, you say, was to
retain a family benefit element, to retain an element in universal credit that dealt with the costs of raising children. And then Regulation 36 in the Universal Credit Regulations you see here prescribed and discrete amounts for each entitlement.
Sorry, what did you refer us to just before that?
I think I showed you 567,
Yes.
which was the Universal Credit Regulations. Before that was the white paper.
Yeah, you've got the white paper. 567 is where we are now.
567, where we are now.
Yes, sorry.
Yep.
Yeah.
Yep.
And are those the currently applicable amounts then?
They are, yes. The point we take from this table is that they are discrete amounts for discrete elements. The standard allowance and then each element. Yeah. And I'll show you in a second. That's a reflection of, child element in particular, that's a reflection of the test in section 10.
When you say child benefit, you actually mean the child element? Don't you?
That was a slip of mine, I mean child element.
Sorry, just for my own benefit.
Yes, for your own benefit.
So the child benefit, the one we were talking about before, which is not part of universal credit,
Yes.
is that regarded as a family benefit for
It is,
the
yes.
purposes?
Yeah,
Right.
that's Commission and UK. So Commission and UK, which Mr. Delamere will take you to, was about both child tax credit and child benefit. Child benefit still exists. It's not a universal credit.
sorry, child benefit,
Still exists.
yes.
It's not part of universal credit.
It's accepted to be a family benefit within Article 3(1)(j).
Child benefit.
Child benefit.
Yes.
Yes.
Yeah. And what we say, Mr. Delamere will flesh out these points when I hand back over to him. But first, you can't just roll the old entitlements together and say no part of the scheme is coordinated. In particular, not where Article 3(1) risks govern access to the additional elements, in particular here, child
And
element.
sorry, just going back to 567, the childcare costs element,
Yes.
that's presumably in addition to the child element, is it? Right. And is that regarded as a family benefit or not?
Well, there's no case law on it. It's not part of this case. I might have to ask you to address that question to Mr. Delamain when he stands back up.
Well, or it may be that the Secretary of State could help with that. Whether the childcare costs element, how the Secretary of State regards that. I would assume that as it's an element of universal credit, they probably also regard it as not being a family.
Yes, it would fit entirely with their position that it wasn't coordinated because it's part of universal credit, yes. The second point is, although the Secretary of State argues that this is a global anti-poverty benefit, it's hard to sustain, but one of the benefits that have been folded into UC was a family benefit, and the family benefit is clearly recognisable in UC, universal credit. And now to touch on the points of commonality between them. Overarching themes of this commonality we set out at paragraph 30 of our case, that's at 101. The particulars of those similarities we set out extensively in our Annex A, beginning at 138. They are largely, if not entirely, common ground. I don't want to walk you through them. What I want to do instead is take you to the decision of this court in SC, which has a good précis of the relevant features.
Sorry, you're taking us to...
SC, and SC is at 1248. Some members of this court might recall SC. SC was a Human Rights Act claim concerning the two-child cap, whether it was contrary to the European Convention as discriminatory on grounds of age or sex. And at paragraph 3 of Lord Reed's judgment, that's at 1267, particularly the last 5 lines just above.
But this child tax credit that they're talking about here, oh, sorry, you may be about to come on to
Yes, so you can see from paragraph 3 of this, of Lord Reed's judgment, that it was accepted by the Secretary of State on this occasion, on that occasion, that the aspect challenged was also a feature of universal credit. It is sufficient for the court to consider the position in relation to child tax credit, since it's common ground that the relevant considerations are the same in each case. And those relevant features are set out at paragraphs 4 to 9 following. In brief, paragraph 4 sets out that both are subject to income tapers.
Is paragraph 3 saying any more than that the cap applies to these different benefits?
Well, everyone is, in this case, was content to proceed on the basis that they need the same analysis. So
one can see that.
yes. So the fundamental
from a Human Rights Act perspective, they would.
Yes, but
That's why I was a bit surprised to see at 567 it talks about second child or subsequent child. You get the amount.
child element.
Yes.
Yes. Well, that mirrors child's tax credit again, because you get an increased amount for the first child, and for every subsequent child you get a fixed lower amount. Of course, now there's a cap of 2 children, unless the exceptions apply. And what SC does is point out those exceptions as well. So those exceptions are set out in brief at paragraph 8 of SC. Exceptions are multiple births, adoption, non-parental caring arrangements, non-consensual conception. other point pointed out by Lord Reid, paragraph 5, is that the person entitled to child tax credit is not the child, but the person responsible for the child. So the basic similarity between child tax credit and child element was accepted. Everyone proceeded on the basis that the structure was the same, which is the same. And a particular facet of this similarity I want to draw out is the test of responsibility. Because that was the test modified for child tax credit, and that's the test we seek to modify for child element. In child tax credit, test is at page 484. This is Regulation 3 of the Child Tax Credit Regulations. So you have Rule 1, 3.2 of paragraph 1, the normally living with test. Then Rule 2 applies. You can see from 2.1a, the child or qualifying young person normally lives with 2 or more persons. We've got a tiebreaker. The test in that situation, 2.2b, is the main responsibility test. Of the 2 people the child normally lives with, who has main responsibility? At Rule 3, you can jointly elect who meets the main responsibility test. And then Rule 4 deals with a number of specific scenarios where a child isn't the responsibility of anyone. For example, they're in care, in prison, they claim certain benefits in their own right, or are part of a couple themselves. For child element, 528,
I think you said that these regulations were modified. Was that after, or was it Commission and you?
modified by the coordination regulation. So the test is modified. So instead of there being a normally living with test, there is a test of main dependency grafted on by the coordination regulations.
Right, but that was done after it was established that the coordination regulation applied.
It was never amended in domestic law, and that's just how it applies because 883 is directly applicable.
Right, but domestic law was amended to spare people going through the exercise of saying it's directly applicable. Sorry, I'm not
No,
confused.
domestic law was never. Domestic law was never amended in terms of the regulations were never amended.
Right.
It's just when you apply, the 883 test is applied to your situation.
I see. So if you looked at the actual regulations, you would think it meant one thing, but secretly everybody treated it as meaning something else.
Secretly, perhaps not, but yes.
Right.
Yes. Yes.
Okay.
So the domestic legislation isn't modified, wasn't modified at least, by 883. Then just show the same test in the Universal Credit Regulations. That's at 258.
258.
I put it in 528.
Same things apply. You have the normally living with test at subparagraph 2.
Sorry, which page?
528, I
You said
think it is.
528 first.
Yeah.
I did, and I meant 528.
Right.
Sorry.
Apologise. So, Regulation 4, Universal Credit Regulations, this is the test of responsibility. Paragraph 2 is the normally living with test. The main responsibility test is at paragraph 4. Paragraph 5 is the election between who has main responsibility. And the situations in Rule 4 are at 3. The person isn't responsible for someone with whom they're living as a couple. And at 6, looked after by a local authority or a prisoner. So, same tests, same conditions for the grant of child element and universal credit. And you've seen from the white paper, they have the same purpose. And now, if I can show you, just in practice, what the effect of coordination is.
The effect of?
Of coordination, my final topic. Child tax credit was coordinated. That means that the means to coordinate it administratively exist. If they didn't exist before Commission in UK...
I'm sorry, you said CTC was not coordinated?
Is coordinated.
Sorry, it was coordinated?
It is, yes.
I thought it doesn't exist now, though, does it?
Ms. Smug will correct me. There are people who get it in a sort of residual basis. Maybe not, actually not by this point. But it exists until, in normal circumstances, it exists until you apply for universal credit, and then your entitlement transfers. But there may well be people who still get it, who haven't yet applied for universal credit, have been migrated.
So CTC was and may still be coordinated under Regulation 880.
That's right. That's the position, yes. And of course, there are the administrative means and systems to coordinate it. And we can see what coordination does from the HMRC manual, which is at 2948. Which gives the worked example of a worker called Alfredo.
Can you just give the page again? Sorry, page
2948. The page 2949 is upside down. I don't know if you can you have the means of flipping it over. But this is a simple two-page summary of how it works. Both child tax credit and child benefit, as my dear lady Rose asked, and guardian's allowance. So if we just work through this example of Alfredo, he is a Spanish national living and working in the UK. He is resident here because of 492/2011. He's a worker. He's in the same situation as Ms Simkova, only Ms Simkova has no partner. Markus is looked after by grandparents. Child tax credit's UK legislation. Alfredo is subject to it as a UK resident and worker. So that's the Article 11 test. The legislation applicable to Alfredo is UK legislation. He therefore applies for UK benefit, and when he does, Article 67 comes to his aid by treating his children as resident in jurisdiction. If the main dependency test is met. And that is, in practice, the effect of child tax credit and child benefit being coordinated. And the test of residence that is modified for child tax credit by the coordination regulation would also be modified in child element.
You wouldn't be able to claim both. You wouldn't be able to claim both.
You wouldn't be able to claim both?
CTC and child benefit.
Yes.
Not the child element, the child benefit. He can claim CTC and child benefit,
Yes.
and the child element of universal credit and child benefit, but I don't think he can claim CTC and the child element of universal credit.
Yeah. For the simple reason, if you don't have an ongoing claim to child tax credit, you can't claim it anew.
So you say they must have in place, even if only now, for the child benefit coordination, means of checking whether you really do have the children in wherever you assert you have them, and whether you really are mainly responsible for them.
Yes, well, yes. And for doing the administrative work behind the scenes to actually coordinate them with, e.g. Slovakia. So, in sum, child element is a discrete entitlement. It's function identical to child tax credit. It's got the same purpose and conditions for its grant as child tax credit. And the UK has a number of coordinated family benefits. The administrative structures must exist and be well established. Unless I can assist any further, I'll hand over to Mr. Delano.
Thank you, Mr. Counsel. We're very grateful.
So in substance, our case is that nothing has changed. That what was CTC, a fully exportable benefit like child benefit, whose exportability required, as a matter of direct effect, the disapplication of the residence test contained in the old scheme that was inconsistent with the requirements of Article 7, 113, and Article 67 in the regulation. That disapplication is required to the like extent and for the like effect for the child element, because it is functionally the same benefit. The only material change between the two benefits is the fact that now, in order to get child element, you must first show that you can claim universal credit. Apart from that feature, there is no other feature that has changed. Yes, there has been a harmonisation, if you like, of the means testing provisions and the income testing provisions, so that the same rules are applied across all of the benefits now consolidated into universal credit. But since means testing and tapering, contribution, etc., is not relevant to categorisation, the fact that those common rules have been introduced is not material. The other attributes, the fact that the payment is dependent upon showing that you have a child or a family responsibility, that's unchanged. The cap is unchanged, and the exceptions to the cap are unchanged. It is functionally the same thing. And therefore, we say, functionally, the same consequence is required, which is that Regulation 4, the now operative residence test, should be disapplied for the child element, and only for the child element, in just the same way that the HMRC was disapplying the old test when the legislation was applicable to give effect to the direct effect of the regulation. So that's the terrain of argument. And what the Secretary of State wants you to accept is that now that the child tax credit element turned into the child element is dependent upon prior receipt of the standard allowance, which we accept the standard allowance is social assistance, that changes everything. So now that it is no longer an independent benefit, but a benefit that you have to access through the gateway of a claim to universal credit, that changes the analysis, such that that which was formerly exportable is no longer. And that's what raises the question of perspective. Do you simply look once and for all at universal credit in the round, its standard allowance and all its potential additional allowances, and reach a judgment on that in the round? Or do you look at each discrete and separate element, to the extent it is a discrete and separate element, and parse that. Now, I emphasise the words to the extent that it is a separate element, because the analysis in relation to the child element is particularly clear. The conditions of entitlement are set out in section 10. They require you to have responsibility for a child. That is the triggering condition, a triggering condition to be a family benefit. And the amounts are clear. And how the taper works and the income provisions work is simply a question of maths. If you have no income or no material savings, you'll get the maximum amount. And that will taper down to zero using the tapering provisions, and the additional element attributable to the child element will always be calculable through those maths. So that's the terrain of battle. And it's only if you insist on looking at universal credit in the round that you have the problems identified by the Secretary of State, which are that Article 3 risks do not appear throughout universal credit for every element. As Mr. Castle has shown you, Article 3 elements don't appear in the basic allowance. They only appear in relation to potentially discrete elements. And on our analysis, it's the element-by-element focus that is required. And that analysis, we'd suggest, is supported, and I accept, and I'm going to accept this repeatedly about the CJEU jurisprudence, such as it is. It's parenthetically, it's not a tower of detailed principled reasoning, but in the case of CG, which went to the CJEU 2 days before IP completion day and generated a ruling about 3 months after IP completion day, a case about universal credit and a case about discrimination under the Citizens' Rights Directive, not under Regulation 883. In that case, the Advocate General, very much parenthetically, in a footnote to his main analysis, suggested that universal credit was composed of separate allowances, and his citation of Commission in the UK, the case that dealt with CTC and child benefit as family allowances, suggests, and I put it no higher than that, suggests that he inclined to an analysis that those elements were still to be treated as coordinated family benefits. We've...
Sorry, the suggestion of the Advocate General is what?
Is that universal credit, which has replaced CTC, is nevertheless composed of an allowance which may in part be coordinated. We've addressed this in paragraph 24 of our written case. It's the Delphic footnote 19, which you'll see in the electronic bundle at page 1746. As to what the expression universal credit covers, see paragraph 25 above. That's a paragraph saying universal...
Paragraph...
We're looking at footnote 19 to the Advocate General's opinion.
Wait, on what page, sorry?
It's 1746.
Is it? The foot?
These are footnotes.
These are footnotes.
Well,
These are all footnotes.
They're all endnotes.
Oh, I
it's
see.
really
I see.
confusing.
They're all endnotes, right.
Yes.
Sorry, which one are we looking at?
19.
19, thank you.
So 19 is a footnote to the text that appears at page 1733. It's a footnote to paragraph 42.
Oh, right.
I've never seen the AGOs produced in this way before. It's markedly unhelpful, but I apologise on behalf of the law reporters.
I see. So he's regarding Commission and Parliament as authority, or at least an illustration of the fact that universal credit is a variety of allowance.
Indeed, that's the suggestion. That's the plain suggestion, because if you go back to paragraph 25 of the Advocate General's opinion, he explains how universal credit was put together. That's page 1729. its objective is to replace several other social benefits which have ceased to exist or are still in force, like the JSA and ESA, income support, WTC, child tax credit and housing benefit. And then at 42, where the footnote appears, he says,
Sorry, 1729, the first paragraph you refer to is
paragraph 25,
25, thank you.
which is the paragraph also referred to in the footnote.
Yes.
I need to show it to you. Then in 42, he's addressing the question of classification under the Citizens' Rights Directive. And it's in that connection, he says, I observe that it's common ground that it is lack of resources that forms the basis of CG's application for universal credit for herself and her children. So in other words, he's actually saying here that for the purposes of the Citizens' Rights Directive, which employs a different test, it is social assistance. But remember, social assistance means different things in different connections, the point I emphasised right at the beginning. And it's that, when he's describing the lack of resources point, that generates footnote 19. So back to footnote 19, now that you've seen the context for it. What he says is, as to what the expression universal credit covers, see point 25, i.e. it's the 6 consolidated benefits, it also serves to designate a variety of allowances. That's plainly a reference to the child element, amongst other things, some of which may be governed by special rules of EU law. See Commission in the UK, which is, of course, the case about CTC, which has become the child element.
Oh, right.
So that's why we say that the Advocate General, who is the only person who has grappled with this issue at all, and even then it is obliquely, in a case in which the issue is not being argued, has adopted an approach that has suggested that the correct approach is an allowance by an allowance approach.
That is very parenthetical.
It is. I don't seek to argue otherwise, my Lord. I'm going to make exactly the same concession about Commission and Parliament and Commission and the Barnett case, because the reasoning there, as a question of syllogistic application of principles to facts to result in a conclusion, is not identifiable. It's simply contains conclusions that the benefits are severable without any analysis of the underlying test of severance that's being employed. So I don't come to defend the adequacy or the comprehensiveness of the reasoning. That's one of the reasons why I hope realistically from the outset our position has been that if there is a jurisdiction and power to refer, that is the appropriate course, because, to use the cliche everyone reaches for at this stage, the law in this respect is Protean. It's very much in the early stages of development.
I mean, also, couldn't it be said that he somewhat misstates the objective because he's left out, as I understand it, the social assistance element of universal credit?
He hasn't left it out with respect, my Lord, because if you go back to paragraph 42, he's basically concluding, which is all he needed to conclude, that for the purposes of the Citizens' Rights Directive, universal credit was social assistance. And right. he wasn't...
I was just taking issue with what he describes as its objective in footnote 25. That seems a misstatement, or a non-exhaustive statement of view.
It's certainly non-exhaustive. I don't think he's saying that each and every...
Even though he seems to present it as exhaustive, but it isn't.
He says a variety of allowances, some of which may be governed by special rules of EU law. And I think that's an entirely accurate analysis with respect.
Sorry, I was looking at footnote 25. Are you reading 42?
I think you're looking at
it's footnote 19.
25.
Ah, right.
It's paragraph 25 is the paragraph in the main body that says...
I'm so sorry, yes.
My fault of exposition, my Lord.
Right, I was looking at paragraph 25, quite right.
Now, the problem with the Secretary of State's approach, look at the whole benefit, do it all in one, is that in a scheme of varied allowances, some of which plainly do turn on Article 3 risks, what the Secretary of State is tacitly inviting you to do is to adopt a test of predomination. In other words, the Secretary of State is saying, look at universal credit as a whole. National law treats universal credit as a single benefit. The predominant purpose of this, the only common denominator running through all of the allowances, is the prevention of poverty, the provision of a subsistence income. Anything else that's added on as a bolt-on to that doesn't detract from that central common denominator, and therefore it's that common denominator that dominates or determines the characterisation of the benefit. So in other words, there's a test of predomination employed. And the problem with that test is it has nowhere been used in the case law of the CJEU for that function. The case law of the CJEU instead shows that if there are two rival characterisations under Article 3, go back to Tolley, is it a sickness benefit? Is it an incapacity benefit? If you have that type of situation, you're struggling to categorise it within the boxes in Article 3, then the case law does say you use a test of predomination. But the case law also says that where it is a hybrid benefit and one and only one candidate function or condition or risk being addressed is an Article 3 risk and the other is a non-coordinated risk like homelessness or poverty, there is no test of predomination if it pursues a mixed or dual function between a single coordinated risk and other uncoordinated risks, then it is treated as a coordinated benefit. And what the Secretary of State is seeking to do is to import that test of predomination that chooses between rival Article 3 risks and to use it in order to force the characterisation of the benefit as a whole and all of its elements, despite the fact that those elements respond to Article 3 risks, as social assistance. So when you actually look at the Secretary of State's case, it is as much a part as our case predicated upon an analysis that has no explicit foundation in the jurisprudence of the CJEU. Our approach is at least grounded in the objective approach, the hybrid benefits approach, and the nascent doctrine of severability. And we say ultimately, when you strip back the arguments, there are 5 reasons why the approach of the Secretary of State and the Court of Appeal are wrong. The first reason, and I'll set them out in advance and then I'll unpack them each in turn. The first is that it attaches decisive importance to national law characterisation. Decisive importance to what national law says constitutes the benefit, when CJEU case law shows that that is not the correct analysis and that what is required is the application of a uniform and objective EU law test to the benefit in issue. In other words, EU law will look at the substance and decide whether or not the substance is such as to meet one of the risks in question, but it is not going to be affected by the national law categorisation. And that must include decisions about whether or not to have benefits separately, whether to bundle them together in one structure, whether to apply a common label, whether to decide to administer one benefit by its own administration regime, or to have a single common regime for a range of benefits. So that's the first point. The very use of an objective EU law test to produce a single approach and single meaning is the beginning of an approach that rejects a national characterisation. The second...
It strikes me that it's one thing to say what is required is an EU law test, and that EU law test may in turn refer to the substance
of course
of the national law as determinative.
Of course it's going to look at the substance of what's being provided. It absolutely has to apply that EU law test to that which is being provided. The key point is that the fact that national law characterises this as a single benefit is not determinative. It can't be.
No, not necessarily that it puts a particular label on it. Characterisation is a matter for EU law.
Yes.
It has to look at the substance
Agreed.
of it, not the label that's put on it by national law.
Agreed. But the reason it has to look at the substance is precisely because the intention behind the legislation is that EU law is going to look under the hood at the substance of all of the like benefits, so that when you have rules on aggregation or coordination or non-duplication, you're looking like for like and saying, is this person receiving a family benefit here and in Luxembourg? You have to look under the Luxembourg label as much as the English label when you're deciding on, for instance, how to apply the cumulative benefit rules in Article 68. And that's why the case law emphasises that the test is ultimately one of EU law, looking at the substance of national law. That's the first reason. The second reason, the second problem, as I flagged already, is that the approach of the Secretary of State effectively invites departure from the hybrid benefits case law, Hughes and Newton, and it effectively seeks to sidestep the operation of the SNCB category, which was created precisely for special benefits which were primarily about poverty reduction, but as an ancillary or supplementary matter, remember the language I emphasised earlier this morning, also address one of the Article 3 risks. And that's our case. The third point is that the approach of the defendants and the Court of Appeal marginalises to the point of abstraction the CJEU's case law on severance. Now, I readily accept it's not detailed case law, but you can immediately see that if you have an objective EU law test, you need, if you're looking at the substance of a national benefit, to decide where it is that the coordinated benefit begins and ends. And so any test of severance is really the flip side of identification of the benefit that's being coordinated, and it must necessarily be a test of EU law, not national law, because if you were to apply a national law test of severance, that would be a threat to the uniformity of the application of the regulation. The principle can't be that if you mix things up or lump them together, the regulation ceases to apply. The lesson of disability living allowance shows that to be obviously the case. And so what the Secretary of State's case really rests upon is the contention that the DLA cases can be distinguished because the two components, the mobility component and the care component, were fully independent of each other. Whereas in this case, you only get the child element if you've shown an entitlement to the standard allowance. So because there's that relationship of prior satisfaction of the Section 4 and 5 conditions, that's determinative. And there's literally nothing to support that as a matter of principle in the severance case law. Though I accept that issue hasn't been addressed directly in any of the case law. Fourthly, and here we very much agree with the points the Air Centre has made, the result urged by the Secretary of State leads to a potential triumph of form over substance. You can engineer your way out of the application of the regulation simply by consolidating benefits and creating some form of hierarchy, even though the practical reality in relation to CTC, which was means tested, is that very few of the applicants for CTC would not have been in receipt of either income support or working tax credit, because the amount of income that you needed to receive CTC was so very low that you would either be entitled to working tax credit, which was the in-work benefit, or income support, which was the out-of-work benefit. So it does look like a triumph for form over substance. Now, I should be very clear here. There is a suggestion in the footnote to the written case that we're somehow accusing the Secretary of State of bad faith by making these points about design. There's no submission that that was the purpose in redesigning universal credit. That's not our case. If you read paragraphs 100 and 120 of our written case, we never say that. What we say is the fact that that approach would enable that form of engineering, were a member state to wish to do so, is a powerful pointer against that being the correct approach. In other words, you shouldn't allow considerations of design and form generate a result of a kind where something that's transparently the same benefit ceases to be coordinated. And then fifthly and finally, the concerns about practicality and floodgates are, with respect, entirely overblown. That is plain because CTC was perfectly exportable without the system collapsing around it. Exactly the same approach would follow if only the child element were exportable. And what's more, and this is where, again, somewhat parenthetically, our application in relation to fresh evidence comes in, it's absolutely clear from the facts of Ms Simkova's own case that for a number of years, the Secretary of State has operated different tests of residence, in her case, in relation to different elements of universal credit. And the reason I say that is it is clear from her case that, first of all, in 2017, she was allowed to export the benefit until the revision decision in 2019, which has then generated a request for repayment. So she was able, as a matter of UC operation, to export for those first 2 years. It plainly, if you look at the underlying decision-making documents, was a mistake within UC that says because she was able to export child benefit, she should be entitled to export the child element, not picking up the supposedly now material difference in test between the two, because the child benefit has always been exportable. But then critically, since 2019, she has been denied or refused the child element, but she has been permitted to receive the housing enhancement for children, which is another element, even though Markus is residing in Slovakia, and even though that is not only known to the DWP, but is the basis for the decision that they took on the 17th of October. And she received that enhanced payment until 2024, at which point it ceased, and again, repayment is being sought in relation to that. So the fact pattern of this case shows that as a matter of administration, the DWP is perfectly capable of operating different residence tests for different elements of universal credit. And if that's the case, all of these unevidenced assertions that what we're seeking would generate some kind of catastrophic redesign of universal credit falls over. So let me take those points in turn. An objective test on the merits. We set out the relevant case law at paragraphs 37 to 41 of our written case. You'll be relieved that I'm not going to take you through this blow by blow. That would be tedious advocacy. You could probably charge me with that on other counts, but not on this one. Unsurprisingly, given the centrality of these terms, the CJEU employs its standard approach, which is to say that in a part of legislation that must necessarily have a uniform meaning, the term in question has to have the meaning supplied by and only by EU law. And so much is really plain vanilla. That means, as we explain in paragraph 39 of our written case, that the formal characteristics aren't relevant, the legal mechanism by which the member state implements the benefit is relevant, and the way that it is classified as a matter of domestic law is not relevant. But the case that illustrates this most importantly, that you analyse the payment in issue on its own merits, is the Lacheb case. And I'm going to take you to this in some detail because it's an important authority. It's page 2251 of the electronic bundle. Now, the facts of this case are quite complicated, but it's significant because it shows that a, if you like, parasitic entitlement or increment that is available only as an add-on to another benefit receives no difference in treatment or analysis for that reason. There is no trace in this case of reasoning that says, for instance, well, because the benefit we're arguing about, the child bonus, in this case, because it's an add-on to another Luxembourg benefit, it must receive the same characterisation as the parent benefit. No, they don't do that. They simply look at the increment on its own merits. So the facts...
What was the legal context?
So the facts are complicated, my lord. Let me explain.
The legal context, which regulations would we concerned with?
It's Regulation 140871. So it's the predecessor provisions.
It is the predecessor.
Yes, but it's functionally the same as Regulation 883. So the facts were these. There were two workers in the family. The family lived in France. Mr. Lacheb worked across border in Luxembourg. Mrs. Lacheb worked in France. That parallel work generated entitlements under the Luxembourg allowance and under the French allowance. And that led in Luxembourg to the application of what is now Article 68, which I showed you earlier, where the Luxembourg authorities, who are obviously well used to this problem because frontier workers are everywhere in Luxembourg, they had a concrete system for the payment of what was called a differential supplement. And that was effectively the difference between the more generous Luxembourg family benefit and the less generous French family benefit. You could only get the top-up differential supplement if you were entitled to the Luxembourg family benefit. And the Lachebs received that benefit. You can see that from paragraph 19 of the report. What then happened is that Luxembourg introduced something called the child bonus for all those who were already in receipt of Luxembourg family benefits. So the child benefit was itself an entirely...
The child bonus.
Bonus, rather. The child bonus was an entirely ancillary payment. You can see that from the analysis of Luxembourgish law at paragraph 16, page 2255.
Sorry, what's the point you can see?
If you look at the new Luxembourgish law,
yes,
described at 16, introducing the child bonus, you can see from Article 1 of that law, for every child living either in the joint household of his father and mother or in the household of the father and mother has sole responsibility, and for whom an entitlement to family allowance accrues, then you shall get this extra sum called the child bonus. So the child bonus...
Page, what was it again?
Page 2255, my lord.
Thank you.
The child bonus was an increment to the already existing Luxembourgish family bonuses.
Family allowances.
And the allowances. Then what happened is that how you received the child bonus was changed by a later law. You see this at paragraph 18. I warned you the facts were dense. Paragraph 18. And what was decided by this later ducal regulation was that for those who were receiving the top-up payment, the differential supplement, the child bonus would be paid by way of cash payment. But for those who were just receiving the standard Luxembourg family benefits, effectively you got a tax offset.
Sorry, so those who are receiving the...
There were different ways
yes,
of delivering the sum of money that was the child bonus.
So if you were receiving the bonus, how did you receive it?
So if you were getting differential payments because you were a cross-border worker and you were being paid the difference between the French and the Luxembourgish family benefits by way of a differential supplement, you got a cash payment. If you were not, you effectively received it by way of a sum that you could set off on your tax return.
So the Lachebs were entitled to the cash payment?
They were entitled to the cash payment. They then challenged the regulation introducing the cash payment because obviously they wanted to receive the tax benefit to reduce Mr. Lacheb's tax bill in Luxembourg. Obviously, it was...
Oh, I see. So if you got it in cash, you couldn't offset that.
You just got extra cash.
Right.
That's the difference between. So let's suppose...
So why was there a benefit in... Was that cash tax then?
I
don't understand why it was a benefit. I would have thought you'd prefer the cash, but...
The child benefit, if you received it in Luxembourg, the child bonus was effectively something that you could set off in your tax bill. If you were getting the differential supplement, you got cash instead. That's the essence of the difference between the two. The Lachebs wanted to challenge the regulation on the basis that it was not consistent with the ducal regulation creating all this. And the government's of Luxembourg's answer to all this is, we have to do it this way. We have to introduce it by way of a cash allowance because that's the only way that is consistent with the regulation and its rules against overlapping benefits. So the reason why we have to pay it is a cash bonus to the differential supplement is to have a system that complies with Article 68 of the regulation. So the Luxembourgish authorities were defending this difference in treatment by saying this child bonus is a family benefit. Because it's a family benefit, the coordination rules apply, and the only way that we can meet Article 68 is if we pay it in cash rather than allowing you to use it by way of a tax credit. That's the terrain, very complicated terrain, for the dispute in question. But the central issue in the case was the child bonus a family benefit? That was where you get to as the end dispute in the case.
That's the uplift to give you the more generous Luxembourg over the French.
Exactly so. And the critical thing to see in the analysis, starting at paragraph 28, page 2258.
I'm so sorry. You said in answer to my lady, it's the child uplift element. Isn't it the child bonus element?
It's the child bonus element that was
payable in cash.
Yes.
Child bonus payable to everyone. If you're in Luxembourg, you get the benefit of it via the tax system. If you're a migratory worker, you get benefit via cash payment.
Exactly so.
That's the element we're talking about.
That's exactly so, madam.
All right, okay.
I thought that you only got the bonus if you were a foreign worker. So you would not. So what you were getting was the French benefit in France, and then this extra bit in Luxembourg.
So you got the extra bit in Luxembourg, which was called the differential supplement already, and the child bonus was then on top of the differential supplement.
So there are three stages, are there? There's the basic family benefit.
Correct.
You had to be in receipt of that to get a child bonus.
No, you have to not.
You had to be in receipt of that to get a child bonus. Exactly so. Yes.
If you were a migratory worker, you had this differential family supplement.
Correct.
And it was the existence of that that produced a different treatment as to how you were paid the child bonus.
Effectively, for those who were in receipt of the differential supplement, who were necessarily only cross-border workers, because it was addressing a situation...
That's the structure we have to have in our heads. Right.
The critical thing is that the analysis of the child bonus is in no way determined by, influenced by, or affected by the status of the parent benefit. What you won't find in any of the operative reasoning is reasoning that says, well, because the differential supplement is a family benefit, the child bonus must be a family benefit. Or because the differential supplement is effectively a reaction to the coordination of different family benefits vis-à-vis the underlying Luxembourgish family benefit with the French benefit. It follows that an add-on to it must be a family benefit. There was none of that axiomatic reasoning that says because the child bonus is subordinate to a scheme of family benefits, it is necessarily a family benefit. Instead, that element, which is in functional terms exactly like child element, is simply looked at on its own merit with the usual test applied to it.
I mean, they weren't having to look at the other situation. Were they? I mean, if the the family benefit, which you had to be in receipt of, was not in the relevant category. That was not a point they had to look at, am I right?
That's absolutely right.
The question that arises here is simply not one that arose in that case.
Well, it didn't.
Right? Or am I wrong about that?
You're right in the premise that the underlying benefit to which it's attached was a family benefit, not social assistance. Exactly. And here it is social assistance.
Yes.
But my point is simply that factor is not pointed at as determining the analysis.
I mean, that's a fair point, but why should it be?
Well, because if there was some kind of predominant purpose looking at the round test, the short answer to all of this would be the Secretary of State's argument. This is a supplement to a family benefit. It must be a family benefit. Whereas the Secretary of State saying it's a supplement to something that is social assistance, it must be social assistance. And that kind of axiomatic reasoning doesn't take place. What happens is that even though the allowance is parasitic upon the other allowance, it's analysed in its own terms.
Because for other reasons it may not be a family benefit. Is that right?
For other reasons.
Yes, isn't that why that's why they had to look at it separately?
They simply had to look at it and ask whether or not the conventional objective test is met. And what they then say is the means of payment aren't relevant. The fact that it can be paid by way of tax rebate or cash sum is not material. It's paid in respect of a family risk. That is what's material.
But don't they say at 23 that the child bonus is deemed by the Luxembourg legislation to be a family benefit? So they didn't have to.
That's simply saying that the reason that they've done it in that way is in order that the Luxembourgish provisions applying Article 68 can operate. They're saying, effectively, we're going to treat this as a family benefit, and once we treat it as a family benefit, it will fall into the complicated calculation under Article 68 of the regulation for overlapping benefits. Yeah, it's certainly not determinative on the EU claim.
No.
Yeah, no, indeed. Whether or not it was such a benefit was the issue in the case, as Mr. really helpfully points out to me.
But,
so,
and if it had not been classified as a family benefit, well, Luxembourg obviously thought it was going to be worse for Luxembourg if it was not classified as a family benefit. Can you just tell us what that worst outcome?
Well, the worst outcome would be that the jurisprudential basis for passing the second Grand Ducal regulation, namely that it was required to comply with EU law in Article 68, wouldn't exist. Because if it wasn't a family benefit, there'd be no reason not to do that which was required by the primary law, which was to make the child bonus available by way of a tax set-off. Yeah, and it wouldn't be offset, with the result that the Latchebs would be better off, because effectively they'd be getting double bubble.
But is that because there would have been an EU, I don't know, anti-discrimination argument saying...
No. The challenge was purely as a matter of domestic law. So the Latchebs were making a Vares challenge, effectively, to the second instrument, saying you don't need to do this.
Okay. And
it was being defended on the grounds, yes, we do need to do this, because it's only by doing this that we can comply with Article 68.
Right, and they were saying they had to comply, they only needed to comply with Article 68 if the child bonus was a family benefit.
Exactly so.
And what was decided?
It was decided that it was a family benefit applying the perfectly conventional test, but without any trace of any form of axiomatic reasoning that said because it's parasitic upon this or ancillary to that, it follows that this. It's just analysed as an element, even though it's a subordinate element subordinate to a family benefit, in its own right. And you can see the conventional reasoning that we summarise about the objective test set out and applied. For instance, at paragraph 28, see the citation of the case of Hughes. You look in particular at its purposes and the conditions on which it's granted, and not whether a benefit is classified as social security benefit by national legislation, see Hughes. Further, the court's made it clear that the characteristics which are purely formal must not be considered relevant criteria. See Peterson and the case cited. Consequently, the fact that the benefit is governed by national tax law is not conclusive for the purposes of evaluating its constituent elements. Then you apply the test as to whether or not it's social security. That's the test of then, is there an individual and discretionary assessment, or is it awarded as a matter of right? That's applied.
Where are you reading from?
I'm reading from page 2258, my Lord, paragraph 28 and following. So they go through the standard test of whether or not it's social security, limb one of which is it entitlement or discretion? If it's entitlement, it's social security. If it's discretion, it can't be.
Right, so your point is, never mind what the Luxembourg legislation purported to deem it to be, and never mind the fact that it was, that receipt of it was dependent on getting some other allowance, which was definitely a family benefit. They still had to analyse whether this was a family benefit. Yeah.
Exactly so. The increment, there is an increment, is simply analysed on its own merits. And that is, without any talk of severance or anything like that, that's exactly the analysis that we urge. And if you start from the starting point that what you're arguing about is the benefit in issue, you don't need to get into arguments about severance, because you can say, all I'm looking for is the payment in issue, which here is the child element. I'm not arguing for anything else. That's the contours of my argument. And that's effectively exactly what happened in that case. So it's on all fours with our analysis, and it is, in fact, impossible to reconcile with the Secretary of State's analysis. And it makes my first point that when you're doing an objective evaluation, applying these criteria that don't attach decisive importance to national characteristics, when you do that, you do it to the benefit in issue, and that is in itself indicative that our approach is the correct one. The second...
sorry, just to get this family bonus, you had to be in receipt either of family allowance if you're entirely a Luxembourg person, or this differential uplift if you were working in Luxembourg but a foreign worker. Is that...
A foreign worker whose partner was generating a benefit elsewhere, yes.
So you had to satisfy either one of those two conditions to get this benefit.
Either way, it was conditional upon prior receipt of a Luxembourg family benefit. That's the point I made at paragraph 16. That was a precondition even of the original law.
The original law granting this child bonus.
Exactly. Article 1 of which said you had to be receiving a Luxembourgish family benefit.
Which could either be the, as it were, standard family benefit or the differential family supplement.
Exactly so. Second factor, the hybrid benefits case law. I'll start on this, given that I'm going very slowly behind. I'll use my 2 minutes to get started on this. Newton is the beginning of the relevant case law on hybrid benefits. But to understand Newton, you have to understand what preceded it. What preceded it is the case of Herx, which is at page 2011 of the electronic bundle, the material parts of which we've set out in our written case at paragraphs 56 to 58, and that's probably all you need to receive or consider. Herx was about the Belgian Minimex benefit, and it operated to provide a minimum subsistence income. One of the conditions for which, a bit like the work commitment, was that you were willing in principle to accept work, and which was analysed as being pure social assistance. Why? Because none of the conditions of entitlement were directed at any of the Article 3 risks. It may be, as a matter of fact, that the person who benefited from it was an unemployed person. It may be that the people who benefited from it were those who just left school and had never been economically active. The key thing is that there was no operative condition by reference to any of the Article 3 risks that governed entitlement to it. And because it had that character, in other words, it didn't address or turn on any of the Article 3 risks, even though it was plainly social security because it was given as a right rather than as a matter of discretion, it wasn't a coordinated benefit. That's Herx. And all the case law that comes after it is about disapplying or distinguishing Herx. And what happens in Newton and in Hughes is that benefits that had mixed purposes to supply a subsistence income or to meet particular very local needs and expenses of disabled people in Newton were presented as being social assistance under the Herx analysis, and the CJEU says, no, this benefit responds not only to poverty or homelessness or whatever it is, but it also responds to one of the Article 3 risks. Because it's therefore a mixed benefit, it's coordinated. And that's what happened in Newton. Newton, very briefly...
Well, perhaps we can come
to chance by arm.
Contain ourselves until 2 o'clock.
Grateful. Difficult, I know.
Thank you, Mr. Delamet. We'll resume at 2 o'clock.